Hello friends, in the series on the income tax cases, today we will discuss an issue in regard a company which is in the insolvency process under the Insolvency Bankruptcy Code. It is a settled law that Insolvency Bankruptcy Code has the overriding effect over the Income Tax Act as far as the claim of the income tax dues against the company which is in insolvency process are concerned. In the present case, the company was in the insolvency process. The resolution plan was being prepared and was approved in regard to the company. The income tax department, out of 4 years, 3 years were covered in the resolution plan, meaning thereby that for the 3 years the department lodged its claim before the insolvency professional, but somehow the department escaped to claim its dues for the 4th year. The resolution plan was approved. After that, the income tax department came to know that it has escaped to claim in the resolution plan the claim of the 4th year dues. The income tax department sent notice to the assessee. The assessee kept his point that the resolution plan has been approved, so it is not possible to now accommodate the claim of the income tax department for the 4th year according to the Insolvency Bankruptcy Code. But the department didn't quash the notices and the proceedings, so the company do not have any option other than to go to the writ court. As all we know that against the income tax order and proceedings, generally the writ petitions are not admitted and the assessee is relegated to the alternative remedy, that is the CIT appeal and so on. But there are 4 circumstances which are broadly covered under the power of the High Court for entertaining the writ petitions. The first is that when the assessee is able to prove that there is violation of the fundamental right of the assessee, then in that circumstances the writ of the assessee can be admitted. The second is when the assessee is able to prove that there has been the violation of the principle of natural justice. In that case also the writ can be entertained against the proceedings of the income tax. The third one is that when the orders or proceedings are wholly without jurisdiction, in that case also the writ can be entertained by the high courts. The fourth one is that when the assessee challenges the virus of a statute, then in that case also the high courts can hear the writ petition of the assessee. In the present case also, the case of the assessee was fit to be heard in a writ petition. So in the present case, the court said that even the statutory dues which are not embodied in the resolution plan cannot be entertained. The department failed to lodge within the prescribed time which is there in the Insolvency Bankruptcy Code. So now the department cannot say that since it is a statutory due, it should be covered, because there should be some finality to the proceedings as far as the Insolvency Bankruptcy Code proceedings are concerned, insolvency process is concerned, because whenever the resolution plan is being prepared, all the interested parties are being informed through the newspapers, through the advertisements. So it is their duty to claim whatever the dues are there before the resolution plan. Once the resolution plan is approved, then the parties do not have any option to again amend the resolution plan. So in the present case, the department cannot claim its dues as regard the taxes, penalties and interest are concerned for the 4th year, which has not been lodged with the resolution professional before the approval of the resolution plan. So in the present case, the assessee writ petition was allowed and the claim of the department was not entertained. Friends, this case is very important as far as the Insolvency Bankruptcy Code proceedings are concerned, because we have to take care that whenever a company is in the resolution plan being prepared, then every creditor should take every sensible step to claim its dues with the company before the resolution plan is prepared, whether it is a statutory dues itself. At the end of this video, once again I am repeating the name of the case. The name of the case is Tata Steel Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 460 ITR at page number 595. The matter has been decided by Honorable Delhi High Court and the date of the judgment is 31st October 2023. Thank you, friends.